before we dive into today's speech. Please type your answer in the chat. Type 1 if it's your first time hearing about CogLeap. Okay, let me see. Okay, many ones. Okay. Yeah, you're so responsive. Okay. Type 2 if you've heard of CogLeap but haven't tried any of our services yet. Oh, 1, 2. Okay, I see 1, 2. Okay, still many ones. Okay, please type 3 if you are already a CogLeap family. Okay, we have some. We have a few. Okay, thank you for being so responsive, my dear audience. For those who are new, welcome again. I'd like to introduce our company first. So CogLeap is committed to helping children with ASD, ADHD, and other developmental challenges thrive. Our parent company, Cognitive Leap, was that holds all the technologies, was established in Los Angeles in 2015. And this year is our 10th anniversary. Our operational subsidiary, CogLeap Center for Achievement, was established 3 years ago. Since then, we have helped hundreds of families. We do this through a variety of services. Firstly, let's look at our clinical services. We provide both ABA therapy and occupational therapy. I believe most of the parents will be referred to those two types of services when your psychologist gave your child a diagnosis. So ABA is a one-on-one clinic-based support to help the children improve their behavior, learning, or independence. And OT is a practical support to develop motor, daily living, and sensory skills. And in the right side is our contact information. So if you're interested in any of our services, please don't hesitate to reach out. And now I'm very excited to introduce our non-clinical services because our kids not only deserve medical support, but also fun, happiness, and confidence. There are a variety of services we provide for non-medical purposes. I'm very proud to introduce our innovative VCAT assessment tool and the Hope Focus system, which is HFS. VCAT is a virtual classroom setting in which your kids need to finish a task while we are measuring their focus, hyperactivity, impulsivity, and self-control. If your kids are struggling with focus, hyperactivity, impulsivity, couldn't sit still in the classroom, and you want to get a comprehensive understanding of their attention level, please schedule an appointment with us to make the assessment. And we also offer HFS training to help kids with those challenges, such as like focus, emotional regulation, and behavior. So HFS is a like one-on-one brain training that enhances kids' focus and self-control. On top of HFS, we also develop a program called Move and Connect. So this is a social group class that can help kids build friendship and social skills. Lastly, I'd like to introduce our app, which is called HFS. And the HFS app is a all-in-one hub for brain training and is designed to connect parents, trainers, and children in one seamless platform. So it acts as a bridge between home and training centers, ensuring that every child's progress is guided with clarity, consistency, and care. So our core features include parent-trainer connection, at-home training support, access HFS training content through subscription. So we will provide like skill-based movement and especially processed bone conduction music that can help the kids regulate their emotions and enhance their brain ability. and the learning ability. So we will have smart notifications that help parents and the children stay on schedule and ensuring that a regular practice and a steady progress. So we also offer like expert curated knowledge, parenting insights, and professional guidance. So those are all our services. At Coglip, we also believe that strong support systems empower families. That's why we host monthly expert-guided webinars to share intervention strategies, parents' tips, and community resources. For example, some of our recent highlights include we welcomed educational attorney Jennifer Chang, who shared advocacy strategies for your children's educational rights. So she's an IEP advocacy attorney. We partnered with Growing Minds Clinic, where Ada Xu gave a heartfelt talk on the unique motherhood journey of raising neurodiverse children. We also very honored to invite Lawrence Fong, an associate professor in the Department of Psychology and Behavioral Sciences at Stanford University, to do a live talk with our Director of R&D, Crystal Go. So those are our past events, and we are very excited to invite them again in the future to give us more speech and support our families. I'm also thrilled to announce our upcoming event, how to become an ADHD expert with an ADHD diagnosis, because Dr. Harwell himself has a diagnosis of ADHD, and he becomes an expert in ADHD. So we want to dig into that. And some information about Dr. Hollowell. So Dr. Hollowell is a Harvard-trained, world-renowned psychiatrist. He has written more than 30 books, and he is also a co-founder and the chief visionary officer. So don't forget to visit our website and subscribe to our newsletter to get more information about those upcoming events. Now, for the exciting part of our evening, I'm very honored to introduce Sunny Rickard. She's a principal attorney at Rickard Law Offices and has completed more than 1,000 estate and wealth planning cases. She's also fluent in Mandarin and served diverse communities. Let's give her a warm welcome. Sunny?
Hi, good evening, everyone. Thank you for sharing this evening with me. My name is Sunny Rickard, and I am a estate planning attorney. Tonight, I will share with you some tricks and points regarding estate planning, especially for families with special needs children. First, I want to express my special thanks to Coglip, especially Fiona, for coordinating and put this event together. And I hope every one of you can gain something from today's presentation. And that said, let's start. You can push the, yeah. So today's topic is planning for your child's future. Trust will and special needs planning, every parent should know. And this just addresses and my contact information. If everyone interested to discuss the more details with me, you are welcome to contact me in the future. Next slide. Oh, sorry, disclaimer. So before our presentation, let's have some housekeeping. I always will say that this presentation is only for education and information. It's not a legal advice. So if someone of you after today's presentation take some actions, I have to disclaim here that we are not going to be responsible for the consequences. Okay, about me, that you can see that I love play tennis, and I am a licensed attorney to practice law in the state of California. and also that I am San Diego probate court appointed attorney and a guardian ad litem. Many of you, if you have special needs kid, you will know that when they turn 18, you need to file, we call the limited conservatorship in the court. And every time a petition like that is filed, the court will appoint somebody to represent the proposed conservatee to make sure that their voice is being heard and their rights are being protected. And we, the court-appointed attorney or the guardian ad litem, will step in that role. So next slide. So let's just tackle the concerns that keep you awake at night. What are your concerns as we age, right? And I'm sure that many of you have sometimes and somewhere that this kind of concerns have crossed your mind. Will my money last longer than my life? If it does, it's you're lucky. You're going to live a pretty comfortable life. But what if your money will not last as long as your life? And who can make sure that I'm being taken care of if I'm incapacitated? And how about my medical decisions if I cannot make that decision for myself anymore? Like to when to pull the plug. Do I want to the plug in the feeding tubes and incubated, just keep me alive? How about my family and the loved ones? Will they fight for my inheritance? And those assets I pass to my children, can they and she keep it? The Chinese have a saying that the wealth will not pass 3 generations. And maybe I don't really like my son-in-law. If my daughter and my son-in-law divorced, will my son-in-law get the share of my assets? And especially for those parents who have special needs kids, that's really the elephant in the room. Who will take care of my baby when I'm gone, right? So I believe that at some point in your life, these kind of questions, even though they did not occupy your life, will somehow cross your mind. Next slide. So the very simple answer to that is the trust and the proper estate planning is like the panaceas, right? And if you know how to use it. So in today's presentation, let's talk about what is trust and what is special need trust and how the trust can protect your children and what kind of asset you can put into the trust and how can you avoid some common mistakes. Next slide. Let's talk about what is trust. So legally speaking, the trust is a contract. And we talk about contract, we think about parties, right? And also this trust, when talking about how it's operated and how it's structured, you can imagine it as more or less like a corporation, an entity. Next slide. And we will talk about contracts. We can't talk about the contract without talking about parties. For any trust, doesn't matter what kind of trust, if it's a valid enforceable trust, there must have what we call 3 parties. Party 1, party 2, party 3. We call it, in Chinese, we call it 甲方、乙方、丙方, right? I believe that some audience today, probably you're from China, and I have to advise you that the trust concept, which here we talked about, is totally different than the trust concept we talked in China. In China, the trust usually is just an investment account. It's not really a trust. You can just use that account to do investment, but it's not a really kind of a trust entity. This is not an entity. Then we said, okay, there's a party 1, party 2, party 3. So a trust is a concept of contract. So basically, this trust is the party 1 in trust of their asset to party 2. I will entrust my property. I will give this property to you, entrust this property to you, but I'm not giving this property to you for your benefit. The purpose I'm entrust this property, I'm giving this trust for you, is for the beneficiary of this trust. So that's the main gist of the trust concept, is entrust some property to the trustee for the benefit of the beneficiary. So if we talk about trust, it's inevitable there's 3 parties: trustors, who is set up the trust; trustees, who is going to manage and control the assets; and the beneficiaries, who is going to benefit of this setup. Okay, next slide. So who is a trustor? A grantor? It's the same meaning. Either you call it trustor or grantor. We call it party 1. Party 1 is the party that is a person that set up the trust. Now, what's the key word of this person set up the trust is the capacity. This person must have the capacity to set up trust. I often heard people, my clients told me, oh, my mom just has stroke. Oh, my mom has dementia. Then your mom probably does not have the capacity anymore, right? So if you lose that capacity, then you're no longer able to set up a trust. So oftentimes, especially some clients have stroke and lost ability to comprehend the concepts and remember things, then maybe it's too late to set up the trust. Okay, next slide. So party B will be the trustee. The trustee can have 3 arms and 6 legs, right? Centolio B, right? 3 heads and 6 arms. This person, trustee is somebody you trust. You entrust your property to this person. This person going to hold the property for you and manage the property for you and distribute the property for you. So this person basically is somebody is your trust. You can put this property in their name for the benefit of your beneficiary. And the most common trusts in the US are revocable living trust. So in that kind of setting, the trustor and the trustee are often the same party. Who you trust the most? Of course, it's yourself, right? You're gonna trust nobody more than yourself to try to handle your own property. Of course, if it's for irrevocable trust, it's a very different story. We'll talk about later in this presentation. Okay, next slide. And then the third party 3, the party 3 will be the beneficiary. Again, in the revocable living trust settings, usually the beneficiary always will also be yourself. So basically, you're going to be the trustor who set up a trust, the trustee who's going to manage the trust, and also you're going to benefit from this trust. Why not, right? Because this is your money. You'll earn it. This money this asset should be working for you. Okay, next slide. So let's just visualize this trust. What it is, what really it is. I like to say, let's think about it. Think about it like a basket, right? When you are alive, you hold this basket, you put whatever you want to into this basket, you take it out whenever, whatever you want to for your own use. When you die or you're incapacitated, you're going to kick the bucket, which is called kick the bucket. You're going to entrust this basket to the next trustee who is going to hold this basket for you for whoever the beneficiary you had appointed to this trust. Okay, next slide. Next slide. So why do we want to set up a trust? Everybody, I don't know if everybody have heard of a probate. Probate is a legal process to distribute your asset after you die, right? There's always a concept of we call gift and estate. I mean, talk about gift is always something you give out when you're alive for free, right? Gift usually means that, okay, I give my friend Fiona $5,000. I don't expect anything in return. And when I'm alive, I give 5,000 to Fiona. That's a gift, right? What is a state? State is the asset you left behind after you die. I died and left a mansion worth $5 million. That's my state, right? That's a distinguish between a gift and a state. So probate is how you're going to distribute your estate after you die. And the probate, you have to remember that probate is the only way to distribute your asset if you don't have a trust, basically. It doesn't matter you have a will or not, or you have some lifetime transfer, then the probate is the only way to distribute your estate after you pass on. Okay, next slide. So why the probate is so horrible? We talk about why is probate, the probate actually has an advantage because it's going to be insured. The court wants to ensure that your asset actually pass on to your beneficiaries as you wished. You write a will that, okay, I want to give to my son, I want to give him 50% of my asset. I don't really like my daughter, my oldest daughter, so I only won't give her 10% of my asset. And I really like my youngest daughter, and even though that she's not my son, in Chinese tradition, his son is always a little more than daughters, but I still want to give her 40% of my assets. So the court will ensure that actually your estate will be distributed as you wished in your will. You set up this way, or you don't have a will, then what happened? Then the court will distribute your asset according to the law. Whatever in the California's probate law, whatever decided who is going to be your heirs, your beneficiary, the court will make sure that your asset is distributed that way. And also the court will make sure that your creditors, if you owe somebody money, that debt is being paid, especially the taxes. We have a lot of taxes to pay in the US. The court wants to make sure that before you distribute your asset, you have paid your debt. And often this process, it takes a long time. And in California, the probate process usually takes more than 18 months. Everything moves smoothly. So that process usually takes about 18 months. If it is disputed or there's some unclarity of the will, or there's some unexpected event happen, it even takes longer. Okay, next slide. I'm sorry, the previous slide. The previous one, I'm sorry. It's how to protect your children with trust. It's 13, slide 13. But anyway, so how to use this trust to protect my children? For a very simple sentence to describe it, because when you die, your revocable living trust becomes irrevocable. So basically this is the one word explanation. And why is that? So let's talk about the type of trust. Okay, next slide. How many trusts have you have you heard of? Have you ever heard of these trusts before? You know, revocable living trust, special needs trust, revocable trust, ILIT, irrevocable life insurance trust, irrevocable trust, irrevocable trust, real property trust, charitable remainder trust, foreign trust, offshore trust, you know, a DIN trust, a NIN trust. There's so many different kind of trusts. I don't know how many of you have heard these kind of trusts, but this is always kind of confusing. What kind of trusts are these? But put a simple way, there's only two kinds of trust. One is revocable, the other one is irrevocable. And just remember, only the irrevocable trust has the functionality to protect your asset. If it's a revocable trust, it does not provide the asset protection. What does it mean? Okay, for example, I like to say that the school bus scenario. You're driving a car, you hit a school bus. There were 20 kids on the school bus. Then every single family can sue you. If you have real revocable living trust, whatever the asset you put in this revocable living trust will not be protected. Means that every single family of those kids injured in the bus can sue for your asset in that revocable living trust. But if you put an asset before that accident happened in the irrevocable trust, you lost some control of those assets, then that irrevocable trust has asset protection functionality. Means that if you hit the school bus, have 20 kids injured on the bus, that asset in the irrevocable trust are protected if it's structured correctly, properly. So that's the reason we said, okay, we set up a trust, but that trust in your life is revocable. However, after you pass on, that trust becomes irrevocable because that's power to revoke it, only you have it. Once you pass on, nobody has the power to revoke or modify it anymore. So that trust becomes irrevocable. That's why the property you put in the trust can provide asset protection for your children. Okay, next slide. So that, you know, of course, that's just a very simplified statement. Revocable trust doesn't have asset protection. Only the irrevocable trust has asset protection function. Then what is a special needs trust? The first thing we have to make clear, special needs trust is a kind of irrevocable trust. Anytime we talk about SNT, the special needs trust, the first thing come to our mind is a irrevocable trust. And what's the purpose of we to set up this special need trust? The main purpose is to make sure that asset in the irrevocable trust, in that special need trust, will not affect the beneficiary's eligibility to the public benefit. What does that mean? Usually, if you pass this on, and if a kid is the beneficiary of the trust, then he has some degree can get the benefit outside of the trust, and that asset usually counted as his or her own property, and that calculation might affect the eligibility he or she to get the public benefit. What kind of public benefit they're talking about? It could be SSI, a supplement, the Social Security supplement income, could be the medical long-term care, because all those have criteria limit how much asset applicant can possess. So the purpose of the special needs trust, number one, is to prevent those assets being calculated as the asset to affect your children's eligibility for the public benefits, including SSI, medical, and medical long-term care insurance. Next slide. So, okay, how then I cannot distribute at all this asset, then why would I set in this special needs trust at all, right? There is a distribution standard. The standard is that first, the beneficiary does not have the control. The control and the protection always kind of opposite to each other. The more control you have, the less protection you're going to get. So first, of course, the beneficiary cannot have direct access to the special needs trust. Secondly, we said the distribution cannot pay for the basic needs because special need and also the another word for special need trust is supplemental need trust. So the distribution can only enhance the standard of living of your children, but cannot pay the necessity of your children, of your children's life. Means that the very basic rents, very basic grocery shoppings, very basic kind of Medicare, medical treatment. So that's the essence of special need trust, that the special need trust can only pay for the government benefit that's not covered. The very basic food, the essentials, the food consumptions, your living arrangement, and the very basic healthcare. Okay, next slide. Another attribute of the special needs trust is the trustee should have 100% discretion how to make that distribution. Traditionally, the trustee cannot make any distribution if in any way it's going to be affect the eligibility of the public benefit. What does it mean? We all know the SSI usually is about $900 per month. And if the trustee decided to, okay, I'm going to compensate the residents, the rent, then doesn't matter how much you contribute, that SSI income will be reduced. Traditionally, the trustee cannot make any kind of contribution toward the rent or utilities or those kind of improvement of your living situation. But let's talk about it a little bit. $900 in California, what kind of a place can you pay for $900? So that's really kind of handicap the trustee's ability to improve the beneficiary's life, right? So think about $900 a month. I don't know, San Diego probably even cannot afford a one bedroom apartment in a very in a relatively good neighborhood. So you have to think about it, make the balance of it. Do you allow trustee actually make some distribution, might reduce the benefit, not kind of entirely limited the eligibility, or you want restrict the trustee's ability to distribute at all for those basic needs. We can talk a little more in the Q&A session and a little more later on this presentation. So that's kind of a decision that often when you set up the special need trust, you have to consider. Do I want a trustee cannot make this, absolutely have to preserve the eligibility for my child to get the public benefit, or I'm willing to sacrifice the amount of the public benefits my child is going to get, but maybe it's greatly going to enhance my child's standard of living. Okay, next slide. So we talk about supplemental need. What are those supplemental needs we're talking about? Any kind of really the kind of enhancement. Like vacations. I often has the parents, I advise some parents that do kids like to travel? If they like to travel, you can tell the trustee, okay, every year you have to ensure my kids will enjoy 2 weeks vacation somewhere around the world. Birthday parties every year when my kids has a birthday, you need to hold a birthday party for my kid. Restaurants, right? The kids like to eating out. Okay, every week you need to ensure that my kids enjoy a restaurant night or whatever. And other kind of hobbies and things. One of my clients told me that their son is really a Partridge fan. I love to see the Partridge games. Then you have to tell the trustee, you have to buy an annual pass for my kids for the Partridge game, something like that. All these are included as a supplement need. So when the parents set up a supplement special needs trust or supplementary trust, I always encourage the parents really think about what are the things that your kids cherish about. What are the things that your kids really enjoy, the arts, films, anything that you can really help improve your kids' life, then as details as possible are put in there. Okay, next slide. So we're talking about the supplementary trust, and we talk about there has to have 3 characters, has to be insured in the special need trust. Is the must be irrevocable, must be set up for the sole benefit of the beneficiary. You cannot say, okay, I set up supplementary trust and I want to benefit my special need kid, and also I want to benefit my son. You cannot do that. Special need trust must be benefit only for that prime beneficiary. And I have to be under complete control of something other than the beneficiary. Okay, I think that's next. Let's talk about what kind of special need trust are there. Basically, there's 3 kinds of special need trust. The first is a first party special need trust. What is first person special need trust? Let's give example, probably it's more clear. That your kids has a car accident and the party has to pay your kids a lump sum for the damage, like $100,000 for damage. This money belongs to your kids. But if your kids get this $100,000, this is going to affect his eligibility for the public benefit. So in that kind of scenario, you need to ask the court to set up a first person special need trust. That money belongs to the beneficiary. It does not belong to anybody else. So the first person special need trust often had some the things that you have to consider about. First is the sole benefit has to be the beneficiary. What does mean? Means that, okay, I have set up the first person special need trust, and my kid's going to go travel. I paid for the kids to go travel, but my kids cannot go on his own. I want his brother to accompany him to Europe. But that special need, the asset in that the first person special need trust cannot pay his brother's expenses. That trust money can only pay the special needs kids. Any other person, if the special needs paid any other person, that can invalidate that special need. So, if that's the first person special need trust, the parents has to be very, very careful. Any expenses can only pay for the beneficiary, cannot pay any person other than beneficiary, even though that person is essential to achieve the purpose of the special needs. Okay, next slide. Okay, let's talk about this first person special need trust. Talking about the money belongs to the beneficiary. So what happens if this money is not from beneficiaries, from somebody else, from the parents, from the grandparents, from other gifts from families or friends? Then it's called a third party special need trust. This kind of trust has a lot more flexibility, and basically you can set up any kind of expenses that's reasonable for achieve the purpose of the special need trust. In the first person special need trust, we talked about if the kid's brother wants to accompany him to Europe, the first person special need trust cannot pay for the brother's expenses, But in the third party special need trust, that is okay. You can say, okay, whoever go with my kids can also enjoy the free tickets, free air tickets to the destination. That's totally fine. So that's one of the distinguish between the first person and third person special need trust, is that the third person special need trust can use that resources to pay for a different people that to achieve the purpose of the special needs. And then also the other very distinguished points between the first person and third person special need trust is the first person special need trust often has a medical repayment clause. What does it mean? Okay, you put this money away so your kids can get the medical long-term care insurance. So when your kids die, whatever left in that first person special need trust has to pay government benefit, has paid for your kids first. But in third person special need trust, you do not have to have a medical repayment clause in that trust. So that's the second, the key differences between the first person and third person special need trust. Okay, next slide. So the third kind of special need trust we call the pooled special need trust. This kind of trust, often the trustee is not a person, it's a third party charitable organization. This kind of trust usually used if you don't have much asset. Doesn't matter if it's first person or third person. It doesn't matter if third person or first person. You can all both can utilize this pooled special need trust. This basically is organization has many kind of different special need trusts. They manage many special need trusts, but they have a separate account for every single one of them. The advantage of this is if the special needs, for example, the asset of special needs is minimum. It's like 50,000, 60,000. Probably it's not worth to set up standalone that special need trust because the administrative fee is going to be pretty substantial compared to the value of the trust. Then probably the best way to manage the special need is this kind of pooled special need trust because their administrative fee is substantially lower. So for the not doesn't have a lot of kind of asset, those special need trust, this is a very good consideration. It's function almost like exactly like any kind of special need trust, but in the administrative level, it's going to be a non-profit organization to be the trustee and to make distribution upon the request of the whoever is a beneficiary or the representative of the beneficiary. They're going to review the request, and if it is for the supplemental need, they're going to distribute the money directly to the provider or to either the beneficiary or the representative of the beneficiary. Okay, next slide. Okay, let's talk about the fundings. Remember the basket? It doesn't matter really how beautiful that basket you've made if it's not, you need to fill it up. If it's empty, it's just decoration. It doesn't have any other function, right? So you have to remember, I don't know how many times I've encountered this kind of scenario that you said that you have this beautiful portfolio and have so many documents put in place, set up the trust, but the clients forget to fund it. Means that put the asset into the basket. So funding is very important in terms of estate planning and trust setup, because if you don't fund the trust, it's like you never had the trust. Okay, next slide. So what are the common properties you can put the trust? Real property, of course, the most common is real property. You use a deed to put the real property into the trust. Bank account, you need to change that bank account into trust name or set up a new bank account and the trust name. Investment account, the same thing, very similar to the bank account. You need that account under the trust name. Life insurance is different. Usually, if it's life insurance, we don't advise the client to change the name of life insurance, change the owner to the trust, but set a beneficiary of the life insurance as a trust. So the life insurance, if you want to put life insurance as a owner to the trust, usually it's called irrevocable life insurance trust. It's totally different kind of trust. And retirement accounts say still the same thing. You never change the trust as the owner of the retirement account. Why? Because there is deferred taxation benefit of the retirement account. It depends. You have to have life expectancy, but the trust doesn't have a life expectancy. So if you change the name to trust, that's going to defeat that tax deferred advantage. So you never change a retirement account into trust name. Similar as life insurance, you can change the beneficiary to the trust. But usually our recommendation is you put your spouse as the primary beneficiary, you put the trust as the secondary or the contingent beneficiary. Corporate interest, that's not very important concept. You own the corporation. You need to remember to put that corporate interest, your shares into the trust name. Otherwise, if you don't put that shares in the trust name, when you die, that part of the asset still has to go through probate. Okay, next slide. Okay, and so the other kind of the common mistake is let's talk about the common mistakes. I will give you an example. We don't have time to go through all these examples. These are all real life stories. I just give you an example of a 35 years old will. That's when I just started my practice. This lady came to me that said, oh, my boyfriend of 13 years passed away. And he said that before he passed, he gave everything to me, but I don't know how to get this done. And his brother has not been in contact with him for more than 20 years, just showed up. And he said that he is the legal heir and he wants to get me, drive me out of the house. And he's going to be inherit everything, what I'm going to do. So unfortunately, we looked at the computers, we looked everywhere. We couldn't find a single documents that leave everything to this girlfriend. They lived together for 13 years, but we had to remember that California is not common law marriage. Remember that California is not common law marriage state. Means that if you don't have a license, marriage license, you're not married. Doesn't matter how long you live together. And this person, this boyfriend is a veteran, and he has a retirement account. He has a condominium. At the time, it's totally worth about, I'll say the condominium worth about $400,000. His retirement worth about $200,000. So it's totally $600,000. And we just have to say sorry that, we couldn't find any signed documents. And then the lady said, oh, I remember that he has a safety deposit box. I don't have the keys, but I know that he's in Bank of America. He has a safety deposit box. So we had to go to the court, get a special order from the court to go to Bank of America to look at the safety deposit box. Because we don't have the key, they have to use the hammer to open that safety deposit box. Lo and behold, that under the safety deposit box, we found a 35 years old will. On that will, he left everything to Humane Society. They even didn't have a dog. And this is the things that one thing I want to talk about. You have a will, you have documents, fine, good, great, but do not leave it there for 35 years, even 10 years, 25 years when not even review it. Your family situation change, your financial change, your value changes, your family dynamics changes. So remember, a law, most important law changes too. It's every president came to the office, and some law gonna changes. So remember to review it every few years and make sure that it's most updated. So prevent this kind of situation happen. Next slide. Yeah, we talk about this fill it up, right? The basket is only a decoration if you don't fill it up. So remember, this is so important. I cannot emphasize more. Fill it up. Okay, next slide. Yeah, and we have to remember that especially for it's so many times especially for the blended family. You have two marriages, you have children from the first marriage, you have children from current marriage, your spouse has children from the previous marriage. You have to know what are your properties. California is a community property state. That means doesn't matter if this property under your name alone. If you're married, this property is acquired after your marriage, it's presumed community. So you have to make sure that you have what, right? What is yours, with is mine, with is ours. So if you commingle together, you don't know whatever, and whatever the trust documents or wills are set up, that can only control the property you own. If you don't own it, those documents doesn't control the property, doesn't belong to you. So especially for the blended family, it's very important to know for sure what property is yours, what property is mine, and what property is ours. This is the things you have to remember, distinguish, the character of the properties. Okay, next slide. Okay, now we talk unique consideration for the S&T. I talk about traditionally the S&T is the trustee cannot make any distribution to affect the beneficiary's eligibility for the public benefit. But we know that SSI is only give you like $900 something per month, and that money probably will not provide a very comfortable living arrangement for your child. And also that there's a different kind of the income calculated as your income to eventually reach a number of SSI. So I don't want to expand how it's calculated, but let me tell you this. It doesn't matter how much you pay for the basic needs, as long as you do not give the cash directly to your child. If you pay directly to the rent, the maximum deduction from the SSI is only like 30-something%, for $300-something. So you have to consider, okay, if I distribute some money from my S&T to improve my child's living situation, and he will receive the SSI in amount instead of $900-something per month to $600-something per month. Does it worth it? Sometimes that answer is yes. So when you set up the specialty trust, you have to, really weigh the balances. What is the best interest for your child? So that's the thing that I often advise my client. Do you absolutely prohibit the trustee to make any distribution in any circumstances will affect your child's public benefit, or you allow the trustee in a situation like this, maybe reduce your child's benefit, but still going to be improve your child's life standard of living substantially. So that's the kind of unique consideration for special need trust. Next slide. I don't know how many times I heard this kind of saying that, oh, so much documents and so much things are so complicated. How about I just give the property to my child right now? It's very kind of a traditional Chinese way of thinking things. Okay, I just give my property to my child right now. You have to remember that if you give the property to your child, you lost control. You don't have the leverage anymore to tell a child, hey, You need to visit me when I'm old. If you don't visit me when I'm old, sorry, I'm not going to give you the heritage, this inheritance to you, right? You lost the leverage. Secondly, it's you're going to lose a standard basis. At least this is the law of the land currently, the standard basis. What does it mean, standard basis? Next slide. Okay, let's give an example. You purchased this property like, I don't know, million years ago. It's $100,000. You purchased this property for $100,000. And when you die, this property is $350,000. And if you die, when you die, you give this property to your child, and your child says, I don't care. I don't want to care about this property. And they sold it, and they sell it right away for $350,000. What's their income tax? Zero, because it comes standard basis. Means that if that fair market value when you die becomes the base value. So even though you purchased this property millions years ago, $100,000, the base, but your child sell it for $350,000, but that's exactly the fair market value when you die. Then you get a step up in base, so your child pay zero income tax. But if you give them in lifetime, before you die, you said, oh, hey, my son, here's property, here you go, give to you. Then that base goes with the property. So the same scenario, we can see that the differences. Then your child has to pay $250,000 in income. That's going to be applied as an income tax. So that's that's another kind of thing you have to consider if you want to give the property to your child when you're alive. Okay, next slide. And another thing is, we Chinese have a saying that the wealth doesn't pass 3 generations. You cannot always trust your kids be very responsible for the money. And you cannot, especially you think about, nowadays the divorce rate in the US are over 50%. So who knows, your child is going to married or divorced in the future anymore. So do you really trust your child that they're kind of will be responsible for the asset you give to you give to them, and you're really sure that they will never get into the accident, they will never have a debt, they will never divorce in the future, they will never gonna have some alimony or some support they have to pay, and they never kind of get any bad habit, God forbid, the drug addictions, the gambling addictions, things like that. So you think about that. What's the best way to prevent them to get into this kind of situation? Use the property you give to them, pay the debt, pay the gambling, pay for the drug addiction, things like that. The best way to protect the asset you provide to them, the best way to ensure that the asset can last generations is through the trust. Okay, next slide. And next one is very important, is business succession. That I have clients that owns like many hotels. And of course, then they right now they are operating it, they are manage that. But really, they have 3, 4 kids, but none of the kids really interested in operating those hotels. So how are you going to, make sure that we all have watched this TV series Succession? How are you going to make a legacy? How are you going to make sure that your business live longer than your life? How to make that, making sure that your kids will not fight over this business succession. So these are the business owners must consider when they do the estate planning. And this is often the part that overlooked when the person that conducts estate planning. Next slide. And another thing is the control of protection. And this is many times is related to how you choose the trustee, especially special need trust. And if you have another child, if the special need kids has siblings and that sibling willing to take on that responsibility, great. You know, you can name that another siblings, another person, another brother, sister, or other relatives to take on that responsibility when you die. But often that you're not sure, or you know, the sibling is too young, or they might moved away in some situation. Then what to do? I know that's difficult, but I often advise my clients, maybe you can consider a combination of your relative, somebody in your family, plus a they call it private fiduciary. This is kind of a private fiduciary usually is kind of the company, it's almost like a company. The only purpose for this company is to play this kind of role. The trustees, the conservators, the guardians, to help those people does not have anybody else to take care of them. Of course, in this situation, if you have family member, I think the best scenario, best way to ensure the kids, the beneficiary get the best care, actually is appoint both of them, right? Have so they can make sure that the other party will do their duties. So the trustee consideration is always kind of, especially for special need trust, is always kind of important for the parents to consider. And please remember that explanation, as long as you arrange that. So as the time goes, if the situation changed, if the living arrangement changes, you can always go back to change that. And also that for the kids, I have parents, have some kids has drug problems. In that situation, also, sometimes I do not recommend a sibling, a family member to be the trustee, because think about it, that trustee probably going to face a lot of stress to deal with the situation. So in that kind of situation, if you have a troubled beneficiary, probably consider a professional fiduciary and private fiduciary will be a better idea. So how to choose the trustee is often important if you has kind of special, unique situation. Next slide. So never ignore incapacity planning. When we talk about the wills, trust, we kind of largely talk about, okay, after I die, who's going to do my distribute my property. But as we live longer, many of us probably will at some stage of incapacity before we die. So we have to make sure that at that stage that somebody will make decisions for us, and that somebody will represent our intent, our wishes, especially the medical decisions. I have my own family stories about how difficult it would be to make those family medical decisions. We have statutory advanced healthcare directive, but I often found that's inadequate. So talk to your estate planners, let them know what you really want. What kind of situation you want that feeding tube? What kind of situation I do not want that feeding tube? In what situation I want to be intubated? In what situation I do not want that? In what kind of situation I don't want the treatment anymore? So those talk to your estate planners and in details about the situation. What situation you can move me to a nursing home, right? Those situations, talk to the estate planners, and those often are very important at that point of your life. Next slide. Okay, this is just a flow chart of this the trust. We talk about, when you're alive, is revocable in trust, but when you die, the trust actually becomes irrevocable trust. This is usually we call a flow chart to show you how this trust going to be evolved as the incident happens. I don't want to talk more about it at this point, but if any of you interested to talk more about this, you can definitely reach out to me and we can discuss a little more about this flow chart, how the trust evolve, how can it set up to protect your loved one's interest. Okay, next slide. Yeah, I wish everybody can, enjoy this beautiful scene as we age. Next slide. Okay, this again, let's conclude our presentation. And again, this is my contact information. If you have any questions, feel free to reach out to me. Thank you very much.
Thank you. Thank you, Sunny, for that deeply insightful discussion about trust, wills, and the special needs planning. I believe all of the audience have learned so much from your presentation. For me, it's my first time to heard about there were 3 types of special needs trust. Thank you for bringing that out. Now I think let's give Sunny a brief, a short break before we begin our Q&A session. So Sunny, you can take a round and drink some water and yeah. Okay. So while Sunny is taking the break, we want you. I'd love to invite you to register for our upcoming coffee talk held at the Irvine Center. So it's a great opportunity for every family to better understand our services and a great chance to get to know other families and to know some good resources in the community. So yeah, if you are interested, please scan the QR code and register. Okay, I believe there are many parents who have raised up tons of questions in the chat. So now it's time for Sunny to answer those questions.
I was kind of going through and looking at some of the questions. Please feel free to post more if you guys have any. But I think I saw a couple questions talking about reviewing a trust and what that process would look like. For example, if you already have a trust, reviewing that one and deciding if you need to create a new one that is a special needs trust that might have a different function, or simply doing a review of a trust. Is that, first of all, I think some people are asking, is that something that Sunny does? Does Sunny offer reviews of trusts? And also what that process, what the review of a trust might look like.
Thank you for that question. Well, we do review the trust, but I always advise my client the first option, the best option usually is you go back to the drafting attorney because he or she probably understands your situation and have done this before. The reasons go back to your drafting attorney is because they can do them more efficiently. And we do review the trust, but we usually review the trust by hourly fees that can anywhere between an hour, 2 hours, so anywhere between so $400 to $600, somewhere like that. So after review, we really provide you the pointers. What do we think that trust can achieve, and what do we think maybe you should improve in this session, and what do you think this trust probably did not address this kind of certain issues, and we talk to you about these issues. And in some situation, unfortunately, I have encountered many situations like this, that trust which is so outdated, also kind of not kind of omitted so many important issues that the trustors want to address. In that kind of situation, we usually recommend you to do what we call the restatement. It's basically you still keep the name of the trust. So if any asset that you have funded in the trust already, that's not going to affect those assets. You still keep the name of the trust, but the content of trust pretty much all change like a new trust. So yeah, basically that's two kind of scenarios. One is after review it, is probably just some paragraphs, some sections, some articles need to change, that we can do that for you by an hourly rate. But if we think that the best efficient way to help you to achieve your goals, maybe you just change the entire content, and we will recommend you to do, we call it restatement.
And I think there was a question about, is that the most effective, most cost-effective way to redo a trust is a restatement? It depends.
Well, if the trust was set up initially, it's it has mainly achieved the goals, and I said, oh, okay, I just want to change the trustee settings, or I just want to add one asset to this beneficiary. Scenario like this probably is not necessary to do a restatement. But if you say that, okay, I really want this trust to get more protection function for the properties that pass to my children, and possibly I want this trust can last for generations. In that kind of scenario, you probably should consider of restatement. So it really depends on, how you want to change that trust. If just very minimum kind of changes, property restatement is not the most kind of effective way, efficient way to change that. But if you want to change somehow structure of the trust, of course, probably the best way to do it, just do a restatement.
And then I think we had a number of our people here asking about if they have multiple children. So there's more than one kid, and one has a qualified disability and maybe one or more don't. Would you want to do a separate special needs trust for a child that has a disability, and a regular trust for the other one? What would that kind of structure, what would be the advantages or disadvantages of setting it up that way?
Well, it's rarely kind of necessary when you're living to set up a standalone special need trust. What I mean is, okay, I'm still alive, but I want to put this house into a special need trust for my special need kids. Rarely have that, it rarely is necessary to do that way. Most of the time, I think it's the best way to structure a special need trust is inside your revocable need trust, you set up a special need trust when I pass away, when I die, that this property will designate it to special need trust. So when you're alive, you have the freedom to share whatever the property you have in this trust, right? Because in revocable living trust, you can say, okay, I want to buy my this child the cock leave program, because that's probably not covered by my insurance. What kind of insurance I have, this cock leave program that I really want to purchase for my child. You have that freedom. You can say, okay, I'm going to buy it. You don't have to use a special need trust to reach that, to achieve that purpose. But when you pass away, then if somebody wants to use the money to buy the cock leave kind of program, then has to be from that special need trust. So usually what we recommend clients do is you right now it's a revocable need trust, but in that revocable trust, you give the instruction how to set up the irrevocable, the special need trust when you die. So yeah, I hope that's answered the question.
So just to make sure I understood that, basically you can set up the trust, the living trust, with explicit instructions to set up a special needs trust when you're no longer living. Is that accurate?
Correct.
Okay.
Right. We can go back to the slides that slides 36. 36, by slide 36 is the flow chart.
Okay. I think it's, oh, sorry.
Yeah, this flow chart, we see that this a flow chart. Basically, it's a big document, big things you set up, right? And when you're alive, it's revocable living trust. It is very top. And then there is a dot. Instead the first spouse die, you can set up that way. We let's ignore that part. And the second spouse, that means both parents pass on. Then see the beneficiaries. If you have 4 children, that maybe, you can divide your properties among these 4 children. One of them is special need kids. Then that trust, specific trust set up for that special need special need child, going to be designated as a special need trust. So that's at the very bottom, you see the 4 irrevocable trust. Then you can set up the way that you designated that one of the irrevocable trusts as a special need trust, if that makes sense.
Yeah, I think that's clear. I think there was a couple of people who were asking about that in the chat. I think there was a few more questions that I'm gonna try and get to, talking about trustees. So third-party trustees, fiduciary trustees. I think they were asking about typical costs, but also like longevity. How do you make sure that a third-party trustee will be there for your child for the remainder of their life? What are the kinds of things that you want to make sure about that?
So first about the cost, the trustees cost usually, they charge usually by the hourly. I would say the regular cost of trustee is about $100, $150 per hour. So the longevity of the trustee, as I said, this kind of fiduciary trustees usually belongs to an agency, and that agency most of the time has more than one person and they hire as a fiduciary. And of course, this agency has to pay the bond, has got a license through the state of California. And they were inspected periodically by the state of California as well. They have to reach certain standard. So you can designate one person in this agency to be your child trustee. If this person is not available anymore, usually you can ask the agency to designate another person, or you can change to another agency. And as I said, that most of the time, if you have some trusted family members, usually I do recommend you give that family members the power to choose the private fiduciary. That give you the flexibility if that the caregivers or that the trustees in the agency no longer available anymore, then you have a successor trustee, successor person to continue that task.
Awesome. I think we also had a couple of questions about, there was one question about co-trustees. Can you name people? So like, for example, let's say it's 2 siblings of a disabled child. You have 3 kids. Could you name the other 2 as co-trustees? Of
course you can. But again, you have to consider that sometimes the siblings probably have different opinions. If they disagree with each other, then what's the mechanism you input there to resolve that disagreement? And also that not necessarily the 2 children all cares about this disabled kids, or they they're I don't know, sometimes maybe one kid is more caring, probably another kid is just more free spirit. So definitely you have to make a balance to think about who is more fit to be in that position. And of course, if you have very kind of responsible, caring kids, they all love the disabled child, even though you think that they have different opinions, but they all from the right place. They all want to care of that the siblings. You definitely can name the two siblings as a co-trustee. And you can even give them authority that one trustee can delegate their power to the other trustee. You can provide that power. You can say that, okay, if one trustee is not available to serve, he or she can delegate his power or her power to the other party. You can definitely do that as well.
So it sounds like it depends on the way you set it up, the trustees. Like you could do it whichever way that you wish. It sounds like,
right.
As long as
exactly.
it's in there.
Right. Exactly.
I think there's a couple more questions about the benefits again. Can you quickly remind everybody for a special needs trust, what are the things that it would be able to pay for and the things that it wouldn't be able to pay for and the benefits that might be affected by that?
Yeah, that's for example for the SSI. The SSI is about $960 something per month right now. I think that when you calculate your resources, there's two kind of income they're going to consider. One is kind of direct income, is dollar by dollar, right? If you get say, okay, I give you $200 from this trust, then that will be deduct from the amount SSI provided. For example, if you say, okay, from this trust, I'm going to distribute $200 in cash for the beneficiary, then the SSI will deduct $200 from the amount they're going to pay you. There's not an income they calculated called in-kind distribution. What is in-kind distribution? It means that I do not give cash to the beneficiary. For example, this apartment probably costs like, I don't know, $2,000, and my SSI only pay for $900. So I really think this is the best kind of option for the disabled child. Then I use the special need trust to pay $1,100 toward this apartment. This is called in-kind distribution. It's not cash to the child, it's paid for his or her benefit. Then this kind of in-kind distribution, I think there's a maximum how much you can deduct from the SSI amount. I think it's $370 something. Don't quote me, but it's something around that apartment that is about $370 something. So the SSI can only deduct their benefit from 900 something to 600 something. So, so that's the things I say. The basic needs, what the basic need? The living arrangement, that's basic needs, right? The rent, that's the basic needs. Sometimes the electricity, the utilities, that's also considered as a basic needs. And the basic Medicare, the healthcare. Basic healthcare means you see the primary doctor. If you are hospitalized, the necessary hospital stay or very necessary kind of these operations, these are the very basic needs. So any kind of distribution of payments toward this kind of basic needs are considered as some sort of income or benefit to the beneficiary. So traditionally, special need trust, you cannot contribute anything toward this kind of special needs. But as cost of living and things kind of evolve as the current situation, sometimes you have to balance, what is best for children. And supplemental needs are the government money will not pay for. The SSIs pay for your rent, for your food, for your things like that. Basically, that if that rent and utility is a basic needs, then maybe, hey, I want to put a nice sofa in the apartment. I want put some decorations or some railings to assist my child to mobility. That's not basic needs. And the food, if you buy the bread or the very basic kind of milk, eggs, that's basic needs. But I buy some supplemental kind of nutrition supplements, or my kids really enjoy. I don't know. I cannot think of this thing right now, but something that's not really to keep him alive. Let's put that way. You can buy those things to improve the standard of living. And some medications not covered by the Medi-Cal, by the insurance. Like I, for example, I said the COG leave, some programs may not covered by the Medi-Cal, by the medical insurance. Then you can use special need money to pay for those kind of services. And that's not covered by the insurance. And definitely, I have give examples of traveling, restaurant, birthday parties, movies, and seasonal tickets to sports games, and things like that. All those you can use special needs trust. This all supplemental. It's not necessity for your child to live on, but it's to enhance his or her standard of living.
Okay, I think it's already 8:29, maybe the last question, and then we finish our session. Okay.
I think that someone, maybe one or two people, they're asking about personal property like the home being placed into a special needs trust when the parents pass, and whether things like having a home or a personal property like that in a trust will affect the let me just check the question again. They're asking about when personal property is placed into a special needs trust when the property owners pass. Would that beneficiary be able to still live in that home if it's in a special needs trust? Would that affect benefits? What's the situation for personal property that is in a trust? I think
if it's rent-free, if it's rent-free, yes, because that's counted as distribution. You live this house rent-free. That's considered as in-kind distribution. And also that in this kind of situation, I always ask the parents, how realistic for your disabled kids living in that house alone? You have to consider that as well. If your kid's able to live independently in that in the residence you leave to them, sure, great. But most of the time that probably he or she is not able to live there independently. So yeah. And strict speaking, yes. And if the kids can live there for free, rent-free, it is considered as a distribution. It's in-kind distribution. It will affect his the amount of his SSI.
Okay. I think that's all we had time for. Thank you so much for your time with us here. I think a lot of people are asking for recording of this and some copies of the slides and stuff like that. But I just wanted to check with Fiona, are we planning to post this video? Is this going to be something that parents can refer back to later on?
Yeah, yes, of course. We will distribute it through our newsletter. So just keep an eye on your email. Yeah, okay. So thank you again to Sunny for sharing your expertise, and to all of you for being such an engaged audience tonight. And we hope tonight's session gave you valuable information and insights. If you found this helpful, please stay connected with CogLeap through our events, newsletters, or by reaching out to our team. Have a wonderful evening, everyone, and we look forward to seeing you again next time.
Thank you, everybody.
Bye.
Bye. Bye.